Hello and welcome back to Fin340 Real Estate. Today we'll be going over chapters 9 and 10, which are pretty brief and they deal mostly with mortgages, promissory notes, and deed of trust. So again, chapter 9 deals with mostly promissory notes, the mortgage, and foreclosures upon those mortgages. And then chapter 10 deals with the deed of trust, which is fairly close to a mortgage with some small legal differences in what constitutes a deed of trust. So very briefly here, a promissory note is just an agreement between two parties that one party will repay the other. That's the promise. In the promissory note, you basically need to list who, what, in this case, what land, for how long are they going to have the loan outstanding, and how much and what interest rate will there be charged upon the loan. The agreement is said to exist between an obligor and an obligee. The obligor is the borrower. The obligee is the lender. This is separate, different, opposite way from lender-lendee, exactly there, or lease or leasee. Okay, so it seems backwards from the norm. The obligor is the one who is obliged to repay, which is therefore the borrower. That's how you can remind yourself of this. There will exist often in a promissory note what is known as an acceleration clause. This is a clause that accelerates the payment. If you don't make a payment on time, let's say 30 days late, there is a clause that activates that says you must make payment on this within, say, 10 days of time, or we will accelerate the payment due for the remainder of the loan, i.e. foreclose on the house or the property. So this is just a way of getting back money that has not been paid if there is a late payment on the promissory note. Okay? This usually leads to the event known as foreclosure, which we'll talk about briefly here in a little bit. And the last part of a promissory note is a signature. So you will require a signature to say, yes, you agree to enter into this agreement in which you will receive money that you can use to buy the house and then repay the amount of the loan. Now, the promissory note itself is not secured. It does not come with the security, i.e. there's not a collateral property of the house immediately upon the promissory note. A promissory note which does not come with the collateral house is simply a personal loan, or a loan from one entity to another, an unsecured loan, debenched loan, a few other words for it there. Okay. Once you attach a mortgage to it, which is listed in the promissory note, this promissory note has a mortgage attached to it. Now it is secured against a collateral property known as the real estate that you are actually trying to purchase here. Okay, so again, the promissory note does not automatically give you collateral to the property. It has to be secured by a promissory note or a deed of trust. Okay, it has to be secured by a mortgage or a deed of trust. Okay, so it must have that additional contract in place. So mortgage instruments, which is what secures that promissory note, is the agreement that says if there is no payment on the promissory note, then the lender has the right to take possession of the real estate property. That is technically what a mortgage is. Before, you were often taught that a mortgage is the loan agreement. That's not true. The promissory note is the loan agreement. The mortgage is the securitization of the property to the note, the collateral. Okay? So together they make up what we typically call a mortgage. But it's key to understand under real estate law, a mortgage is the securitization, the promissory note is the loan itself. Now, mortgages are pretty standard in modern times, but they come with pretty common covenants in them. For example, the covenant to pay taxes, which stipulates that upon this mortgage and promissory note entering in, the owner or the deed holder of the real property, i.e. the person who is purchasing, has to pay the property taxes. The mortgage lender does not pay the property taxes. That's the covenant to pay property taxes. Even if they were to take possession of the property, past due property taxes are kept with the original real estate owner, not the new possessed lender. A covenant against removal is one that's just like in a syllabus, right? So shame on me, you do something and I have to put it in the syllabus because I don't want to see it happen again. So this is one of those covenants where they didn't originally have this. Somebody did it, and of course they had to make up a rule. So the covenant against removal is, if we are going to mortgage a property, you cannot demolish the building on the property without getting permission from the lender beforehand. And this should seem apparent as to why. If we are going to give you a loan for $1 million, and most of that loan relates to the value of the home on the property, and you then demolish the property, it will be very difficult to get the money back if you default on the loan. Of course, somebody, as I said, did this in the past, and the bank found out that, well, they couldn't get the money back. Okay, so they made this nice removal covenant there. You can't get rid of any items on the property without first requesting permission from the bank. Now, you can remove chattel items from the property because they're not real estate, but large real estate items you generally cannot alter. This rule is not meant to keep you from making repairs to your property. In fact, there's other covenants for repairs, that require that you maintain the property in good condition, okay, if you're under a mortgage, and that's because they want to maintain the resale value should you default. Okay, so again, you can make those adjustments to the property, but you just simply cannot remove large portions of the property, like demolishing a building or uprooting pieces of real estate that were attached but could become removable and then taking them away. Okay. Sometimes this includes precious artworks or statuettes in the property as well. Okay. Covenants of insurance. This is a pretty big one, particularly for young people. The covenant insurance says that while you are under a mortgage, you must hold mortgage insurance. Effectively, if the building were to burn down, then we would like for you to have insurance to pay to rebuild the building, or at least pay back the value of the equity in that building to the lender. Okay? So they don't want to simply lose the house because you don't have insurance. So long as you have a mortgage, you must have insurance due to the covenant of insurance. If you are getting a mortgage through a home buyers association, you typically will get an additional line of insurance that you have to pay along with your mortgage in order to ensure that you have appropriate insurance there that the federal government will back. Okay, so it's not private insurance, it's additional insurance provided by the federal government, and in addition to that, you may also be required to purchase private insurance. The insurance can cost you quite a bit. A large portion of your monthly payment may be due to insurance, so it's not something to just look over. The alienation clause says if you are going to sell the property early, if you will alienate the property from the original agreement, send it outside the agreement, then the mortgage becomes due immediately. So this effectively says if you try to sell the property, then the bank has the right to take back all of the amount not paid on the house mortgage out of the proceeds of the property. And you get to keep what's left, if there is anything left at all. Okay? And if there's anything that has not been paid, then they can come after you for what's called deficiency judgment, which we'll get into under foreclosure. Condemnation clause is just a clause where we talked about before condemnation of eminent domain. So if the government should come in and try and seize your property, and you would receive money for that property, and you had a mortgage on the property, then the bank would be able to take their portion of the mortgage back out and give you what was left of the proceeds. So again, all of these basically say the bank's going to get their money, and you will have to pay them, but they're also not going to be due for the taxes, and you cannot just get rid of the house or watch it burn down. Okay, so they're just trying to protect their loan investment there. The act of foreclosure. There are two main acts of foreclosure. Foreclosure is what happens when you simply don't pay your mortgage. There's judicial foreclosure, which happens through the courts, and non-judicial foreclosure, which is simply a offhand agreement between the bank and the individual. So they say, clearly, the individual comes to the bank and says, I'm not going to be able to make payments on this property. Would you please foreclose? This is the non-judicial. And the bank says, sure, we don't want to really incur all of these legal fees, so we will just take possession of the property and deal with the sale of it thereafter. So in 2008, there were a lot of non-judicial foreclosures because people were laid off and they realized they wouldn't be able to make payments. So often if you go through non-judicial routes, the banks are nicer. They're nicer to you. They're not happy, frankly. So you're still going to be penalized for it, but they will be nicer to you rather than if they had gone through a judicial foreclosure. So a judicial foreclosure is where the bank actually sues you through the court, and the court has to enter into the judicial foreclosure proceedings. That's why the judicial is there. At which time, if they decide you have not made payments over a certain period of time and you have no capacity to do so, the bank will order you to turn over the property to the bank. The judge will rather order you to turn over the property to the bank, and they will take possession for the purpose of sale. Sheriff's auction usually is what occurs, and during that auction, anybody has the right to bid on your property. Any bid that is taken will be used as the value for the house, except for in the case where the bid is less than what is owed on the property. If it is less than what is owed on the property, the bank usually has the right to what's called bid up the loan. They do not have to actually cash pay for the house, but they can bid up the loan. So the example here, for if you have $100,000 remaining on the mortgage and you enter into foreclosure, and the only bid that comes out of the auction is a $90,000 bid. The bank has the right to enter into the auction even if they will not purchase the house and bid up to $100,000. Then somebody else who wants to buy the house now has to bid more than $100,000. This ensures that the bank gets their money back. It's a nice little right provided to the bank and no other institution in order to make sure that they don't simply lose money on the sheriff's auction. So any money that is additional on top of the foreclosure auction that is not taken back by the bank is given back to the original owner. So if suppose somebody came in and bid $180,000 for the house and there was only $100,000 outstanding for the mortgage, then the $80,000 would go to the original owner as part of their property. It would just be returned back to them. This is typically not the case. Usually, a mortgage is owed more than what the foreclosed auction will earn. Foreclosures usually go for very little money compared to the actual market value of the property, which is often why I tell people it's a very good method of investment if you're going to make an auction on that purchase through the auction for your property, because you can get them for fairly cheap. Okay? Now, public auction is a very weird method of doing things because they are just advertised in the newspaper very briefly. They're not very well advertised, which would be strange, you would think, because you would want the bank to advertise a lot about the auction occurring so they can get more bidders. More bidders typically will update the price to the market value, but they don't do it. Auctions are not really well attended except for by very well-known real estate investors in your area, your local area. There are typically a handful of wealthy individuals who frequently visit the auctions and just buy up property. And they continue to be able to do this and then sell the properties at market value and earn an income from that. So if you are looking to get into the foreclosure business, you need to be made aware of where the auctions are happening. You have to look in the newspaper or look at the sheriff's office where they will advertise the auctions. But again, it's not really well known. Sometimes you will drive by a property and see foreclosure auction signs posted on the front lawn. And that's another way to figure out that that place is going up for auction. But sometimes those signs may say the auction is tomorrow and you had better get there. Well, you need to have the cash available at the auction in order to bid. At the auction, if you make a bid, you are usually required to put down 10% down payment, and then you have an additional 10 or 30 days, depending on the state, to provide the remainder of the balance of the auction bid. So if you were to bid $70,000, then you would have to put $7,000 down on the day of the bid sale, and then 10 days later or 30 days later, you must provide the remaining amount of money, the $63,000 there. Okay? If you don't have the cash available, you will not be able to go through with the transaction. Okay? And it will go back up for auction. You'll actually end up being penalized for that, but it will go back up for auction if you decide to not be able to pay. So you usually, if you don't have time to enter the foreclosure sale, you cannot usually get a loan for these sort of bids unless you are a large real estate company who effectively goes to a bank and says, please give us an unsecured loan, we will buy properties which you can then later secure. But you need to be a pretty large purchaser of real estate for them to do that because they want to be able to ensure they will be paid back the amount of money that they're going to give you. And giving unsecured loans is a pretty dangerous thing for banks, so they tend not to do it. All right, deficiency judgment, as we discussed before, is where simply the bank doesn't get enough money back from the auction and they need to come after the original owner to get the money back. So this is a way, if they lost money on the property, they can recuperate that value from any other unsecured assets that the individual may have. Now, unfortunately, if you're foreclosing on your house, you usually do not have a lot of other unsecured assets to be selling to anyone. Okay, so it's not a very good way of getting money back. We say trying to bleed a dry beet, or you can't get blood out of a beet is another phrase. Basically, there's no money there, so you won't be able to get it regardless of what your deficiency judgment suit is going to try and get back. So it is a way to get money, though. Be very careful about that. If you are buying into the foreclosure market, you need to be very well aware of statutory redemption, and it depends on the state in which you reside. Statutory redemption basically says that after a year from the foreclosure, the individual who was foreclosed upon has the right to make up deficient payments and pay back the value of the property to retain the title. That means after a year of the foreclosure sale happening, the person who made the foreclosure purchase does not actually get to take possession of the property for a whole year. That property remains in possession of the foreclosed individual. They may or may not have moved out of the property, The bank may have changed the locks, but nobody may be in that property. So maintenance of that property is nothing. Okay? In fact, vandals may move in and vandalize the property. Or the original owner may simply break in. They used to live there, it's pretty easy, and vandalize the property. And people who bid on foreclosure auctions know this, and that's one of the reasons that foreclosures go for a very low amount of money. And why you can get them as pretty good deals. Now, I've often said to students, if you're going to enter the foreclosure market, simply keep $10,000, $20,000 extra dollars. The vandalism that's going to occur in the property is not substantial. They're not going to blow out a load-bearing wall. They will probably destroy drywall. They may destroy the floors. They may break windows. So $10,000 to $20,000 will be enough money in general to repair necessary parts of the building and bring it back up to marketable value. Okay? So it's not a bad idea to enter into foreclosure markets if you are well advised ahead of time that the auction is occurring, if you have the cash available and you have enough money set aside for repairs. Then you can make a lot of money under the foreclosure market. But again, you need to be aware that it will take at least a year from the foreclosure time for you to actively take possession of the property. So because foreclosures take so long, they're not a great idea for flipping houses if you're trying to flip houses on a 1-year window. Okay? Flipping houses on a 1-year window would generally require that you pay up in cash or get a mortgage for the amount that you need and then try and sell the house later. Again, if you're going to get a mortgage, you're probably going to pay market price for the property. You're not going to get that deep discounted value. So be very well aware of statutory redemption. And in some states, statutory redemption depends upon how the foreclosure happened. So you need to read up, depending on the state you're buying in, what exists as far as statutory redemption laws if you're going to enter that foreclosure market. Chapter 10 deals with deed of trust. A deed of trust is the same idea behind a mortgage. The whole difference here is very nuanced legalese. Basically, and under a deed of trust, the person who keeps the title during the time in which the loan is outstanding is some appointed trustee. Under a mortgage, the individual who keeps the title during the time of the loan is the banker or the lender who's going to make that loan. That's the difference. Now, this is even made more silly because today most banks have a trust department. And simply, if they're going to make the loan, they appoint the trust department to be the trustee under a deed of trust state. And under a mortgage state, they simply let the bank or lender keep the mortgage. So the title is still being held in the same building, it's just on a different floor. Okay? So this is a very almost silly legal distinction as to what makes a difference between a mortgage and a deed of trust, except there are some other reasons deed of trust is slightly different. Under deed of trust, because a trustee is maintaining ownership of the deed of title, you don't have to go through an additional process, the court, to make sure that they have the right to possess the title. The trustee makes sure that they have the right to possess the title under deed of trust if there is a foreclosure proceeding. Under mortgage, you have to go through the court in order to make sure that the mortgage company has the right to repossess the title. So because the trustee is the one who manages who owns the title, the speed of recovery on the property is much shorter. Under foreclosure with the mortgage, it can take a year or longer to retain the value of the property. First, you need to wait at least 90 days for you to foreclose upon the property, and then the foreclosure listing may occur after another few months to a year. Speed of recovery under deed of trust states is only 3 to 6 months for the sale of property to occur. And after the 3 to 6 months, the original owner loses their equitable rights in the property. Okay, so it's very quick. And so this may or may not also cause the original owner to lose their statutory redemption right. So we talked about that before under the foreclosure. This would allow you, if you were to enter a foreclosure market, to simply purchase the property and ignore the statutory redemption right. Now, some states do allow statutory redemption on deed of trust, so you'll have to look at the specific law. But under deed of trust, you may be able to take possession of the property under foreclosure immediately, which is pretty nice. So you don't have to wait a whole year of not being able to use the property or making updates to the property in the fear that somebody would, the original owner would be able to retake possession of that property. So some states that use deed of trust listed in your book are Alaska, Arizona, California, Colorado, DC area, Idaho, Maryland, Mississippi, Missouri, North Carolina, Oregon, Tennessee, Texas, Virginia, and West Virginia. Approximately 13 other states use deed of trust in certain areas and use the mortgage in other areas. So that's just like the TORNs and the regular registration system that we had in the prior two chapters. Okay, it's sort of mixed. So the other item that can occur under deed of trust is that the mortgage company is allowed to take possession of the property for non-payment And if you're renting that property, they can take possession of those rents. So the renter's not kicked out. Simply the bank is now the one who accepts the rent payments and use them to pay down the remaining balance of the mortgage. So this is called assignment of rents. And it's a very important property of deed of trust because it allows for the easy recuperation of the loan from the bank on apartment buildings. So it's very easy in these states listed above to get loans for the construction of apartment buildings because deed of trust allows the bank to take possession and obtain those rents should you stop paying the bank. All right, this is the end of the last 2 chapters for your exam. Again, read these chapters in detail. It's a lot of just legalese and parts of what exists in a contract, so it's really items that you just need to read briefly. And then proceed with your exam. It's due end of Sunday.